T minus 1 minute. T minus 50 seconds. T minus 40 seconds. T minus 30 seconds. T minus 20 seconds. Ten, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
What is up, everybody? Welcome back to the Drunk Turkey Show. I'm Daniel. Alongside with me is Big Blue. Jaime's in the back and getting his makeup done and did. He'll be joining us here pretty soon. Blue, how you doing, my man?
He was getting his beard fluffed.
It's looking good, looking good. How you doing, Jaime?
I've been better, man. I've been better.
Oh, no, man. Is it hot out there?
Dude, the heat right now is not the problem, man. Today in the morning, I was running late to work, right? So I kind of like rushed, and I fell down the stairs, dude.
Oh, no.
Yeah, I landed right on my wallet.
Ooh.
So you know, I have a bruise there right now, and it's pretty sore, but oh well, it is what it is.
Yeah, you need to get more cushion in that thing.
Definitely.
More twerking, that'll help. So we got a special guest today. We have a San Antonio attorney. His name is Zach Lutz. How you doing, Zach? Welcome to the Drunk Turkey Show.
Thank you for having me.
Welcome here. Welcome. So you are an attorney here in the city of San Antonio. Can you kind of explain to everybody who you are?
Yes, sir. My name is Zach Lutz, attorney in San Antonio, Bachelor's of Arts in Criminal Justice from St. Mary's in 2012, law school from St. Mary's 2017, and MBA from Texas A&M San Antonio in 2021. I run my own practice, law office of Zachary Lutz, PLLC. I do criminal law, but mainly I focus on family law, probate litigation, estate planning, business, real estate, things like civil law mostly. But I have done criminal law. I've gotten my hands dirty in the criminal arena. I'm not afraid to get back in if necessary. Been licensed since 2019, so I got about 4 years under my belt, and I've done a lot of cases. Like I've been in the thick of it, like courtrooms and really angry parties, like just people that are just totally upset at each other. So that's pretty much me in a nutshell.
Nice. Well, welcome to the show. We're glad to finally meet. Here at Drunk Turkey Show, we cover quite a few different cases. Primarily, one of the largest ones that we've covered here is the Bryan Kohberger case, the University of Idaho quadruple homicide that occurred November 13th. That took the lives of Xana Kernodle, Ethan Chapin, Madison Mogen, and Kaylee Goncalves. Are you familiar with the case? I know we talked a little bit backstage, but just so that everybody is aware, how familiar are you with the Idaho homicides?
Not terribly familiar. I mean, I didn't even know about it until today. I got the topic from your assistant earlier, and so I did some research about it. And basically, as I understand it, some PhD student that was studying criminology allegedly committed this quadruple homicide in this dorm room or something like that. About 4 people got cut up, like straight out of like a horror movie or something like that. And, and then allegedly he fled back to his dad's house in Pennsylvania. And then, after them doing the investigation, they found evidence linking them to the scene or whatever. So that's pretty much all I know. And I heard about like the other stuff that they're doing, like the plea and all that. So that's about what I know.
Got you. Big Blue Hyman, y'all got any questions for Mr. Lutz so far? We'll start off with you, Blue.
Yeah, I was gonna say, well, later on, if you can give us your information, you can put it out there. There's people saying they might need your services. So if you want some,
it is in the description, y'all. So if y'all guys go check that out, you'll be able to find his address, phone number, and email, and all of his contact.
I have no objection to those proceedings.
Awesome. So yeah, you got most of that correct. It was a quadruple homicide in which Bryan Kohberger is allegedly he's been arrested and charged for the murders. It was a off-campus residence house. It was a 3-bedroom home with 6 occupants at the time. 4 who had their lives taken, 2 who remained alive. There's a lot of conversation there about a time frame in which it occurred. So the murders had occurred at approximately between 4 and 4:25 in the morning. We find out during the probable cause affidavit that one of the surviving roommates actually sees the assailant in the house, clad in black with a mask on, but 911 isn't called until noon. Right now, 911 isn't called by one of the surviving roommates. It's called by a friend of the surviving roommates who was summoned to the house. Now, as a defense attorney, having that information off the top of from the get-go, is that something that would favor the defense, just given the amount of time that it took for 911 to be called?
Well, yeah, actually, I think it would, because again, 911 wasn't called by the suspect. It was called by somebody else. Did I get that right?
Right. It wasn't called by one of the surviving victims. It was called by, so there was 2 survivors, one named Dylan and one named Bethany. And it is believed that one of their friends was called over to the house. Mm-hmm. And that person is who called 911.
I see. And we don't know who informed the friend or whatever.
No, nothing. Everything's been kind of under seal. The 911 tape hasn't been released. I have spoken with one of the victims' family members. I spoke to Kaylee Goncalves, Kaylee's mom, and she had informed me that they had spoken directly with the person that called 911. And from what they were told was that he was summoned by the girls. He showed up. The door was... he couldn't open one of the doors to the bedrooms because one of the bodies was blocking it. And that he managed to get it open enough to peer in and see what the crime scene was. And then at that point, 911 was called. And so up until that point, 911 wasn't called.
Well, it's helpful for the defense because there's a big chain of custody issue now, because it's what happened in between those hours, anything could have happened between that time. Now, depending on who informed the friend, that's kind of what I want to know. Cause if it's the suspect, and he's informing one of them, hey, look what I did, he wants to be caught or something like that. If it's him, then that doesn't look good. But if it's some intervening third party, then yeah, I guess it would look good. It depends. That's a big lawyer answer. Yeah.
Right. So to our knowledge, the suspect, Bryan Kohberger, had no connection to anybody in the house. Per the defense's statements, there was 0 connection between Kohberger and the victims. The persons that called 911, or the persons that called the friends over, were the surviving roommates. And so they were cleared early on in this investigation as not having anything to have been, had anything to do with the crime.
Yeah.
Just because law enforcement clears a person, does that necessarily leave them, I guess, closed to a defense's attack? Can a defense basically one of the other persons that it has been highly suspect throughout, the court of public opinion is Kaylee Goncalves' ex-boyfriend. Now, police cleared him. Does that hinder the defense as pointing as him as a possible other suspect?
No, I wouldn't say it hinders the defense at all. I mean, the defense can call them as a witness. Like, I think I was watching one of your other live streams, and like you had mentioned about like if the prosecution calls them or if they don't call them, like can the defense call them? Like, if either side calls a witness, they're fair game for the other side. So if the defense calls a witness, prosecution can cross-examine them and vice versa. So just because they were cleared, like they can still show up in court and have to testify about something.
Gotcha. Yeah. No, what I was referencing in that situation was if I'm on the prosecution and Big Blue's on the defense, and Big Blue has a witness that is on his witness list that I want to cross-examine, but I don't list them as a witness on my list. If Big Blue doesn't, call them up to be examined, I can't call them up, correct?
No, you can't.
Okay. So yeah, then
at least under Texas rules. Now I do have to make a disclaimer, like I'm a Texas attorney and this is Idaho. So like it's different rules there, like a little bit. There's a lot of overlap, but there are some differences. But in Texas, you could definitely call them if they're on their witness list.
So what do you think about when the defense is relying on a state witness to cross-examine them in effort to come up with a possible alibi for their witness or for their defendant?
Yeah, I know where you're going with this. Frankly, I think Kohberger, that's his name.
Yeah,
I think he might have some kind of mental issue, and his legal team is really struggling to get him under control. Like, because we mentioned that he didn't enter a plea. He did that standing silent thing. He probably ordered his lawyer not to do a plea, so they just had to stand silent. But if I was his lawyer, I'm like, what do you mean stand silent? You need to plead guilty. I mean, you plead not guilty. I'm sorry. Yeah. You need to plead not guilty. And then now they're coming up with this alibi thing. And if I'm not mistaken, it's already after their deadline. Like they had a deadline to do an alibi defense and they're doing it afterwards. So what I suspect happened was the attorney told him, look, you're under some serious trouble here, sir. You need to start taking this seriously or you're going to end up in jail and there ain't nothing we can do to help you. So probably, the alibi is what? Like he was driving around just randomly at like 4 o'clock in the morning away from the scene. Now, I'm not so sure I buy that, but if I were to give him the benefit of the doubt, if I was in fact driving around aimlessly at 4 o'clock in the morning, who knows where I was? Like I could have been on 281, I could have been on I-35. I don't remember where I was at that specific time. And but the fact that they're relying on some prosecution witness is kind of interesting. I don't know why it would be on their witness list and not theirs, like you're hinting at.
Yeah, I just don't understand why they wouldn't put that witness as a witness on their side. It just doesn't make any sense to me.
Maybe because he in fact does not have a witness, and they're going to search for some of their testimony to see if they can find something to corroborate that, because that's the best they can do. Like when you have a really bad case like that, you kind of just end up throwing everything against the wall and seeing what sticks. So I suspect that's probably what his legal defense team is doing. Yeah.
You have a question, Jaime?
Oh no, no. I was for the chat. I was reading the chat. I'm sorry.
No problem. So The standing silent thing, that I'm glad you brought that up, because that was something that I had wanted to talk to you about. Now, the defense is claiming that the reason why they're doing that is in some sort of protest to the grand jury. So apparently what had occurred was there was a preliminary hearing that was scheduled, and then the state ended up going and doing a secret grand jury indictment uh, to avoid the preliminary hearing. Now, leading up to that, the state, or the defense, I'm sorry, had filed motions that Bethany, one of the surviving roommates, had exculpatory or could have exculpatory evidence, and wanted to call her as a witness throughout the preliminary hearing. Her lawyers attempted to quash that subpoena. And during that interjection, or during that course of action, they had come to an agreement that Bethany would go and talk to the defense attorneys, and give them her statement of her accounts that occurred that night. And in efforts, in return, they would quash the subpoena, and she wouldn't have to testify. They were preparing for this preliminary hearing, and then out of nowhere, a secret grand jury comes up, indicts him. And in fact, Kohberger's defense team has filed a motion to dismiss the grand jury indictment based on some laws from 1887, but they're throwing that out there. So that hearing actually is on this Friday, I think, on August 18th. And so the claim coming from there is that it was out of protest, because they wanted to protest that the grand jury indictment was unconstitutional, or whatever the case may be. Does that make more sense now as to why he would stand silent?
I guess not really. I mean, because see, grand juries are used all over the place. Like Texas is big on them, and like I don't think there's any case law that says grand juries are unconstitutional. Now, if they had some kind of agreement to have a preliminary hearing, like in Texas, we would call that an examining trial, and you're entitled to an examining trial as long as you do it within a certain time here in Texas. So, I mean, I don't know. If I were speculating, I'm guessing that the prosecutor wanted to get some kind of indictment through and want to just pin him down, because I understand that they denied his bail. Like,
I believe
they're
so.
probably thinking of him as a flight risk, and like they can't afford to have any kind of wiggle room or any chance for him to escape. So I'm guessing that's why they did some kind of clandestine grand jury. But grand juries are very common. Like nobody's allowed in. The defense attorney isn't even allowed in, and they only hear the prosecutor. They don't hear anybody else, and they don't even allow exculpatory evidence. Stuff that would suggest that he actually is innocent. So of course, most grand juries vote to indict. But I still wouldn't have advised him to stand silent. I would have advised him to plead not guilty, because it's almost like pleading nolo contendere, no contest. I mean, and you do that if you're trying to accept a deal with the prosecutor. So
Yeah.
I don't know.
Yeah, I think in Idaho, when you stand silent, the judge automatically enters a plea of not guilty for you. And so, it seemed like it was just, I was kind of curious, as if it was, something that maybe Kohberger was wanting to do, or if this was something that his attorney would have recommended.
No, if you're representing a criminal defendant, the last thing you want is a grand jury, because they always indict every single time.
Yeah, and they're trying to get rid of that right now, and they're using some sort of law that's it doesn't make any sense to me, because and I'll see if I can pull it up, but it sounds like the defense is saying that in order for the grand jury to be valid, they must have been given all of the evidence, and since the defense hasn't received all the evidence that's out there yet, they couldn't have given the evidence to the defense yet, or the grand jury, and that it's by code from 1887 in Idaho law that says that the grand jury is like that there is a reason beyond reasonable doubt for the grand jury there. And I think it's just kind of weird that they're going with this, and it's so old. And it doesn't sound accurate. I mean, that's not what I understand as far as grand jury, that that beyond reasonable doubt isn't the standard in which, for that setting in that court. I believe it's just the preponderance of guilt. Isn't that not correct?
Yeah, I think that is right, because to actually prove guilt, it has to be beyond a reasonable doubt. But I think grand jury is preponderance of the evidence, if I'm not mistaken.
Yeah, 100%. So there's a very strict gag order that's going on right now. Some of it is allowing for some misinformation that is going on. Some of the misinformation, that's out there is in favor of Kohberger. Some of it is not. When it comes to a defense attorney, when there's a lot of misinformation and you perhaps maybe think that your client could have done the crime, is that beneficial to the defense or not so beneficial?
I would argue it's not beneficial. Well, I mean, the gag order, depending on how strict it is, I would say the gag order is beneficial because, depending on how many people are talking and what's being said in that community, like he might not get a fair trial, as I understand, he's out of state, so you got to understand, like an out-of-state defendant that allegedly killed 4 hometown boys, or no, it was 3 women and 1 man, right? If I'm not mistaken. So 4 hometown people, and like those judges and prosecutors, they're elected officials, so it's like they're facing intense political pressure for somebody to hang. So, like with all this public opinion, trying to get people not to talk about it, it might not even be effective, because I mean, look, we're talking about it right now. Obviously, we're not subject to a gag order because we're out of state and we're on the internet. But the more publicity it has, I think the worse the defense team has. Now, there is a remedy for that, but it's extreme. If you'd like me to go into that, I'd be happy to.
Yeah, 100%.
Okay, so like if I was representing him, if I was on his defense team, I would already be thinking about a motion for change of venue. So like he's in a county where like he's being tried in the county where the crime was committed. It's probably something that this county's never seen before. It's straight out of a horror movie. People are cut up in some room. The people are going to want to crucify him. Like there's a very good chance that he's not going to get a fair trial if he stays in that county. So us defense attorneys, like we have a mechanism where like we can file a motion to change a venue where he's tried in a different county. It's got to be in the same state, obviously. Like it could be an adjoining county or something like that. But that's something I would seriously be thinking about if I was his lawyer. Like the people are going to want his blood.
Yeah, I think what they've done, from what I've understand, is that they are bringing in jurors from a different county, but that the court is going to be happening there in Latah County.
Okay.
And so
that's a start.
Yeah. Jaime, do you have any questions?
Right now, just one so far. But since there's a gag order, and anyone under that gag order violates the gag order, what will happen? Like, what would be the outcome of that if they violate that?
I mean, I haven't read the gag order, so I don't know what it says, but typically, like you could be held in contempt, like be ordered to appear before a judge and explain why you did that. And if the judge doesn't like what you have to say, you can get a fine and possible jail penalty.
So if it's a witness and this witness violates it, that witness is no longer able to appear at court?
No, the state would probably have to file a motion to suppress that witness, and the defense would contest it or vice versa. But like they could try, and it would be up to a judge at that point to let that testimony in. I mean, and it might be punishment for one side, you know, like, hey, look, like you violated the gag order. So, yeah, I mean, they're probably not likely going to penalize the defendant because it's technically not the defendant's fault, but the witness could be facing like, you know, either a fine or jail time or both.
So, Kohberger's defense team provided an alibi. Now, in Idaho, apparently, there's a specific date in which you have to have an alibi in, and it's not so much that if he doesn't provide the alibi, that he's contempt of court or anything, but that he wouldn't be able to use an alibi defense come trial if he not provided it by a certain date. And they ended up providing an alibi that he was out driving alone by himself during the commission of the crime. Now, we also know from the probable cause affidavit that he turned his phone off before the crime was committed and then turned it on afterwards, you know, about a little bit in time in there between. So the crime was committed between 4 and 4:25, and his phone turns off at 3 before he leaves the neighboring city where he's from, Pullman, Washington. And then it turns on when he's south of Moscow, Idaho. Do you think, what do you think about, well, first and foremost, if you were Kohberger's attorney, would you have even provided an alibi at this point? I mean, I don't think that this is an alibi that could be used, you know, for his defense come trial. I think that this only hurts him, in my opinion. What are your thoughts on his alibi and the defense's decision to provide it?
I don't think it necessarily hurts him. Like, yeah, like the fact that he turned his phone off during that period, it is suspicious, but in and of itself, it doesn't prove guilt, you know. And again, with the criminal law, it's like you got to prove guilt beyond a reasonable doubt. So, you know, that's enough to prove some reasonable doubt. Not, well, you know, it muddies the water a little bit. Now, about like the alibi, like, again, this is why I kind of think that he's not thinking straight and his lawyers are having to kind of grab him by the neck, you know, like, look, you know, you're under some serious trouble. And I know you think that somehow you're magically going to get exonerated, but no, you need to start facing reality. So they probably did a lot of convincing to try to, like, look, you need to give us something. All right, fine. I was out driving around. You know, okay, fine. He was out driving around. Go tell the prosecutor. You know, so and even though it's late, you know, like the judge is probably going to let it slide because you know, a man's life is at stake. You know, they're seeking the death penalty. So when you have stakes that high, the courts are likely to be more lenient. You know, like in a civil case, you know, it's like you're late on discovery, sanctions, boom. You know, like. So, but when the stakes are that high, you know, the courts are more forgiving. So I think it sounds to me like the defense is doing the best they can with what they have. Like, I really think their client is not thinking straight, you know?
Well, he's grasping at straws. I don't think you know, Idaho is a death penalty state. And so, you know, I don't think they've even offered him as a plea, to be honest with you, given the nature of the crime and how this goes. But, you know, Kohberger's been very adamant that he is innocent, that he said that he looked forward when he was arrested, apparently said that he looks forward to being exonerated. So we'll see.
Yeah.
Would you have, you know, given the understanding of not being able to use an alibi as a defense, and if your client was adamant that, you know, that he wanted to go to trial, would you have given a defense of him driving around, or would you have just stayed silent?
No, I would have given the defense. I mean, because you got to throw everything against the wall and see what sticks, you know, like, and here's a trick that us lawyers have that not a lot of people know. Like, you can plead in the alternative. Like, you can say one thing and you can say something that's contradictory, you know, as long as your pleading is accurate. You know what I mean? Like, trying to think of an example, like, but basically you're pleading two affirmative defenses and they might not be consistent. Like, you just plead them anyway, you know, in the alternative, but without waiving the foregoing. So right now, Judge, we're saying he was out driving around while these murders were being committed, so it couldn't have been him. Eventually, when we get to trial, if the jury or the judge doesn't buy it, then we have to rely on something else, but for the meantime, that's our story and we're sticking to it.
Gotcha. Well, it makes a little bit more sense because I often question that. What's up, big boy?
And I was going to tell him, so what do you think of them trying to bring back the shooting squad as a death penalty?
The firing squad?
Firing squad, yeah.
Yeah. Isn't that still the death penalty in some states? Or I know there's lethal injection, the chair. Mm-hmm. Most states have opted for lethal injection because it's cleaner, or the gas chamber. Yeah.
Yeah. Yeah. The firing squad is only in case they can't get the medicine for the lethal injection.
Mm-hmm.
Yeah. So it's as a backup. So in March, the state notified the court that the state has become aware of potential Brady Giglio material related to one of the officers involved in the case. Now, we've looked through, a lot of the officers and things of that nature. We suspect that what they're referencing to is there was, I think, 2 officers, and it was the first 2 responding officers responding to the call initially had a situation where during the pandemic, the college was protesting the mask and created a sticker that symbolized Soviet Russia, Moscow, their little emblem. And it said it had "We enforce because we care," which is what the law enforcement in Moscow, Idaho, that was what they were promoting about, why they were promoting the enforcement of the mask. Well, anyways, there was an incident where one juvenile placed a sticker on a light pole, and one of these officers came, and that juvenile was with his brother, who was an adult. They separated both of them. They questioned the juvenile without the parents around and things of that nature, and they arrested and charged these individuals with some sort of criminal mischief. They lied in court and stated that there was no body cam footage, and come to find out later, there in fact was body cam, and they claim there's no audio, but there was body cam, and in that body cam, you can see that they had separated the 2 juveniles, and they were talking to the younger one. They can't hear what is being said. Now, their claim was that didn't happen, that they never separated him or talked to him. So I believe that's the situation referencing the Brady Giglio, is that they lied under oath. And then there was some documentation or footage that came forward. Can that affect this the state's case against the defendant? Those prior actions of the officers who responded to the crime. They didn't investigate it. They weren't detectives or anything else in this case.
Okay, so it was like an unrelated case there, where they lied, basically.
Yeah, they lied under oath, but their involvement was just responding to the crime.
Yeah, if I was the defense attorney, I'd bring it up. I'd move to strike their testimony.
Mm-hmm. Yeah.
Yeah. Mm-hmm. That's totally fair game.
Well, what would you think of her going after their training records? She wanted their police officer training records within the police academy. What would that prove?
Yeah, again, that's probably just what I keep saying on here, throwing everything against the wall and seeing if it sticks. Probably what she's trying to get after is are there any holes in their training? Did they skip a day or something like that? Do they have proper certification to do X, Y, Z? Because if they don't have proper certification, that's something else you can attack as the defense attorney. I guess I would do the same thing if I were her. I mean, and see, it's a public defender's office, so they're not getting paid until the end, or they're getting paid by the county. So, I mean, that's a lot of work, to have to sift through training records for these officers. I mean, I guess just to cover my, I probably would ask the same thing, but I'm not sure how important training records are going to be. The fact that they lied on their job duty, that would be what I would be going after.
Now there's documentation where there was DNA found from Bryan Kohberger, and it was found on a sheath that was found underneath the body of one of the victims. Now the defense attorney has indicated or alluded that that sheath or that DNA was placed there. Is it possible that they can get any of that thrown out because of the responding officers and their, issue with the Brady Giglio?
Yeah, it's possible. I think they did something similar in the OJ trial. Like there was some big hoopla about chain of custody with DNA evidence, and that was kind of critical to OJ getting off the hook. But speaking about the sheath, one thing I was reading in my research before this episode was apparently the sheath was left at the scene, but only Kohberger's DNA was on it. Is that right? Or was there other victims' DNA on it?
There was, so we don't know how much DNA was found on it. The only thing that we know or are aware of is that the sheath was found button face down with DNA in the inside of the button that belonged to Kohberger. We do know that there was 2 other DNA profiles that was found near or where the bodies were located. Not necessarily on the sheath or any of those things, but there was some curious wording in that document. For instance, it said that as of December 17th, there was unidentified male DNA where 2 of the bodies were at, right? But as of December 17th, the DNA on the sheath was also unidentified. It wasn't until December 19th when they identified Bryan Kohberger as a possible person connected to that DNA through the genetic tree that the FBI created. And so, I thought it was just a play on words as a tactic to create reasonable doubt.
That's probably exactly what it is. But what I read, assuming what I read was accurate, because the stuff's all over the place. Allegedly, they found only Kohberger's DNA on it. And, an attorney that was writing brought up a good point. Why was only his DNA on it? Shouldn't there be 4 more sets of DNA since that was the alleged sheath that held the murder weapon, the knife?
Right. I'm not sure if it specifies whether or not there was other, victims' DNA. It just specifies that there was a single source DNA that was located in the sheath button.
Okay. Because if there's only 1 set of DNA, then that kind of lends credence to the argument that maybe it was planted.
That's true. If there wasn't any other DNA on, especially where it was located underneath the body of one of the victims who was brutally stabbed in a bed where 2 of the victims laid. And so you had 2 victims, we suspect, laying down in a sleep in the same bed when allegedly Kohberger attacked them. And, we're assuming, that he went in there without the knife sheath attached to a belt. We don't think that came off during the commission of the crime. I think that if possible, that if it did get underneath her body, maybe, and that was the first person that was attacked, I think that there would, that's right. Her DNA should be all over that.
But I think what happened was, this is my theory, is she was the first victim on that floor. He took the sheath off, probably threw it to the side of the bed, and when he started attacking her, maybe she kicked the sheet over it, and then it was covered, so there's no way another DNA can be on there. Because they found it under the body, they didn't find it on around where all the blood was, I guess. But I don't know, the crime scene photos will tell the best answer that. We just had this; those aren't going to be released.
And depending on how much of a struggle there was, if there was in fact a struggle, and say maybe the victim knocked the sheath off trying to defend herself or whatever, and I think you had mentioned something, Daniel, on the last episode, when you're in a when you're in a situation like that, you're not really thinking, so I mean, it's quite possible that the perpetrator just left the sheath there and forgot about it, after it, because it was just too much going on,
Yeah, I think that I very much think that this was Kohberger's first time there's I think he planned this very meticulously. He's very calculated, and there's a difference between like preparing for the crime and then committing the crime, right? And I think we see that in a Linda Lane footage where his vehicle is passing by, and it passes by 3 different times. And on the 4th time, it starts to drive erratic. And what we know is that between the 3rd and the 4th time, Xana receives a DoorDash order. Now, I speculate that because of the location of where their house was, it was a little bit tricky to get to, that they may have left the light on as an indicator to the DoorDasher of where their house was at. My speculation is that once that food order was received, that light was turned off. Now, Kohberger wasn't just in that area. He'd been driving around. If the DoorDasher went and dropped off the food during the time or between the time in which he drove there and wasn't in the area, Kohberger would have never known that light was on as an indicator for food. He may have just assumed that it was on because somebody was awake. And then when he passed by after 4 a.m., sees the light off, he may have just assumed that they fell asleep at that point, not necessarily that they received something. And so once that happens, Kohberger begins to do, allegedly, if it is him, a white vehicle is seen doing some weird stuff. It is doing a 3-point, it's doing a turnaround at one of the apartments, and then it fails to park in front of the house or do a turnaround there. And then it does another 3-point turnaround at the following intersection and then comes back around. And so to me, right away, as soon as it became go time or it was real, he started to make mistakes immediately. And so I can see how he would have forgotten the knife sheath, especially during all the commotion of everything that was going on. I can see that being a situation, especially if somebody is saying something or he's hearing somebody else awake in the house after he committed the crime. According to the probable cause affidavit, Xana, one of the victims, was awake at 4:12. She was on her TikTok, and Dylan states that she hears one of the other, who she thinks is Kaylee, but they suspect it being Xana, say the words, I think someone's here. If Dylan heard that, is it possible that Bryan Kohberger heard that upstairs and went downstairs to go find where that came from? Because he heard somebody talking and, in his hurry to go find out where it was at, it's possible he forgot the sheath. I think so.
Yeah. Panic set in.
100%.
Panic could have set in.
Now, Kohberger is alleged to have committed this crime against 4 individuals very violently, and yet the defense's motion or objection, or for the state's motion for protective order, there is an interesting statement. It states that there is a lack of explanation, or there is no explanation for the total lack of victims' DNA in Kohberger's vehicle. Now, one, does total lack to you mean no evidence, or does that mean based on the nature of this crime, we would assume that there'd be more than what was found?
Normally, us in law, we use plain language. So when I hear total lack, that suggests zero to me, like zero evidence. But I mean, if it's a forensic scientist talking, total lack could mean just statistically insignificant, like not enough to like move on anything, like maybe a strand of hair or something like that. But total lack would imply that there's none. So that would be my final answer, locking that in.
Okay. All right. Well, that's good to know.
And the way I would say is because he's got a PhD in criminal justice, and he's also what was he trying to? He was trying to get a.
He had his bachelor degree in psychology, a master's degree in criminology, and was in the PhD program.
Yeah.
Y'all are saying he was trying to get a job at the police force or something like that?
Yes. Yes.
So as a requisite for the PhD program, he had to be an intern at one of the local police departments.
That's what I was trying to get to. He was trying to get an intern, and he was also taught how to do a forensic cleanup and forensic, I guess, collection of the evidence. I think he would have enough knowledge to be able to cover his body when he left the house and to put everything in away. Like I would say, he probably wore like a jumpsuit or some kind of PPE to be able to just dispose of it before he even got in his car. That's why there's no trace in the car.
Right. And so, I mean, I think that Kohberger, he had prior knowledge of forensics and how this crime would have been investigated. And so I think he took some precautionary steps to elude the investigation, which would have included, dextering up his vehicle to make sure that there was nothing left behind. But yeah, this is one of the statements here. And it brings me to the next question, which a lot of folks are concerned about, which is the genetic genealogy. So apparently, from what I understand from all of the court documents, was that the state had exhausted their traditional techniques. They had gone to the FBI, and the FBI basically was going to do a genetic tree, like an ancestry type of thing, to kind of determine Bryan Kohberger's relatives, to kind of point towards him. Now, what had happened was there was the DNA was found on the sheath that at the Moscow lab. An STR profile was made. That sheath or that profile, a sample of that profile was sent to a Texas lab where a SNP profile was created to determine the genetic tree. While they were doing that, that's when the FBI took over the case and created their own genetic tree, and basically came back to Moscow saying, you should investigate Bryan Kohberger. The state or law enforcement then created a case against Bryan Kohberger and got a warrant for his DNA to match the DNA on the sheath. The state does not want to use the genetic genealogical tree information that the FBI provided. The defense has a problem with that. The defense wants the information from the genetic tree. I don't see how it would make a difference. Now, if you were the defense, how would you feel first and foremost about the so-called tip that the prosecution had, which was the FBI saying, look at my client Kohberger. We did a genetic tree, but you can't use this against him. Is that legal? That seems to be one of the biggest arguments for the defense.
Mm-hmm. I'm not sure I'm following. So like the state exhausted their technology. So they took it to the FBI. FBI took it over, and then they did their own genetic markup, genetic genealogy. And that's like what the basis of this motion here, that there's no connection between Kohberger and the victims.
No. My bad. That was just from what we were talking about earlier.
Okay.
So what had occurred was, according to DOJ policy, Department of Justice policy, the genetic tree cannot be used unless all law enforcement, what's the word I'm looking for? Unless all of their techniques have been exhausted, right? All conventional techniques have been exhausted, and they have no leads. So what occurred during this case was they found the DNA on the sheath, and they ended up creating a profile. They checked it with CODIS and came back nothing. They checked several different people, several individuals that came forward, whether it was the victim's ex-boyfriend or other individuals that they were investigating, and it didn't match anybody. They had no leads, and so because of the policy that allowed the FBI to create that genetic tree, which pointed in the direction of Bryan Kohberger. Now, the FBI is saying that genetic tree that they created that pointed to Kohberger is only a tip. It's only a tip. Mm-hmm. And that the state still needed to build their case against Kohberger and build evidence against them. The defense is upset that they don't have the work that the FBI did. The state has not provided the genetic tree stuff. The state is saying that it is only a tip, and that they have no intention of using any of the information from the FBI that built that tree as evidence against Kohberger, so they don't have to give it up.
Mm-hmm.
And so that's the big argument now.
Okay, I see what's going on now. All right. So yeah, basically it sounds like the state is relying on the FBI's tree then. And since they're not giving it up, that's the prosecution can't like dissect it, like get their own genetic expert in there to either verify or poke holes in that process. So
Right.
that's why the defense is pitching a fit about that. Like they want to examine that themselves and get their own experts. And because state's not giving it up, that means they're being denied that. So yeah, I would put up that argument if I was representing him too. Yeah.
But okay, so let's just say that the defense were to win that argument, and the state has to hand over the FBI work. What is the optimum goal of the defense with that information?
It's very much a crapshoot. You know, like if it confirms like that he did it and it's irrefutable, then it could like bite him in the you know what. But the defense is probably thinking we got to find something to try to get him off the hook. So this is the best we can do with what we have. Like it could very well backfire, you know, and I think the defense team is taking a calculated risk in doing that.
Now, let's just say the defense were to get it and they find out that in the process from it going from the lab in Houston to Quantico, where FBI did their thing, that there was a mishandling, chain of custody was broken. Mm-hmm. How would that affect the STR profile that was created on the sheath and that connecting to Bryan Kohberger's cheek?
If there is a chain of custody issue, I mean, that would be helpful for the defense, because if there is a chain of custody issue, that's a grounds to file a motion to suppress. And, you know, if you can suppress the FBI's work, then what do they have? Like they would have the state's own work, and, you know, like that they already admitted they couldn't find anything. So I think a chain of custody foobar would be helpful for the defense.
But the state isn't using the FBI's work to convict him. So even if they had that part thrown out, my question is, the profile that was created, or, you know, off the sheath, that after later on they got the information or the warrant for Kohberger arrest, and they ended up getting a warrant to test a buccal swab of DNA from his cheek to the sheath DNA. What difference does that genetic FBI stuff do if they're not even planning on using it? If the optimum goal is to suppress that, isn't that where we're at right now by them not using it?
Yeah, I mean, I'm not sure if the FBI has the authority to tell the state they can't use it. I mean, I'm not sure what they're basing that on, like federal, like a federal jurisdiction versus state jurisdiction, because, you know,
it's because they didn't actually test Kohberger's DNA to the sheath. So they're saying that because all they did was create a tree that pointed to relatives of Kohberger and stated, all right, you know, based off of this DNA, we created an ancestry profile. So we have all of these people over here that are related to the suspect. You know, we went and did social media, investigative tools, web sleuth the crap out of it, and it pointed to this guy who was a relative to all these other folks. This guy here has a white Elantra and he lives in the area. More than likely it's him. But since the FBI did not test Kohberger's DNA to the sheath, they can't use that. That's their argument. They can't use it in court because they didn't test it themselves to the sheath. Had they, then that would have closed out the investigation, and I think they would have.
But whose argument is that? Is that the state's or the defense?
That's the state's argument.
Okay.
I think the other reason is because there is some laws that they're going around because they can't use certain DNA trees against people when it comes to convictions.
Yeah, that's true too. But again, it's like all right, if the optimum goal is to suppress the genealogical evidence, and that would mean that they wouldn't be able to use that against Kohberger. They aren't using it against Kohberger. Wouldn't we just be back at square one?
Well, yeah, I mean, so they didn't. Like, all right, now we're talking solely about DNA. I mean, like, was there anybody that placed Kohberger at the scene? I don't think so, right?
No, there's nothing that places him at the scene. Apparently, that is, from what I understand, the only DNA in the house, including on the victims,
well,
under their fingernails.
If the state doesn't have any DNA evidence and they don't have any eyewitnesses placing him at the scene, then why did they indict him? I mean, it doesn't seem like they have any actual evidence then. If
there is a slight eyewitness, but I'm not sure if they've done a lineup with Dylan. She saw the
guy with the mask.
The guy with the mask with bushy eyebrows, over 5'9", I think, walking out the house
with no knife.
With no knife, yeah,
and not covered in blood.
Not covered in blood.
Mm-hmm. I don't know. It seems really sketchy to me. I mean, like, you know,
Now, so basically, from what I understand, this is my understanding of how they came across Kohberger and how they investigated him. So on the 29th of November, so this incident occurred November 13th. The 29th of November, or the 25th of November, Moscow, Idaho Police Department shares with WSU Police in the neighboring Pullman, Washington area that they're looking for a white Elantra 2011 to 2013. Kohberger drives a 2015 Hyundai Elantra. What they end up doing is they end up going out and doing a search and canvassing areas of vehicles that are registered to students that have a white four-door sedan similar to that Elantra. They find Kohberger's on November 29th. From my understanding from several different articles that are out there, because the way they investigated this case was they pulled out warrants for the cell tower that was nearest to the victim's residence. And they were aware that this incident had occurred between 4 and 4:30. So the warrant was for all phones that connected to that tower between 3 and 5, within a half-mile radius of the house. Now, Kohberger has his phone off at 2:30 or 2:47. His phone does come back on between that 3 and 5 period, but he's about 3 or 4 miles south of Moscow already. And so he's not coming up in this deal here. From what I understand is they kind of just put him on the back burner, didn't look at him. December 16th, and the reason I believe that's December 16th, he's pulled over by Indiana police officers traveling to the Poconos, according to where he lives, Pocono Mountains in Pennsylvania, and he's staying over there until he ends up getting arrested. According to a couple of different articles that have come out, December 19th from the New York Times article is when the genealogical tree comes back and is pointing at Bryan Kohberger as a suspect. December 20th, December 20th, there's a white Hyundai Elantra that is crashed, that is found in Eugene, Oregon. And according to a Howard Bloom article, the police get excited about that vehicle. And so that tells me that if they thought that Bryan Kohberger was the crashed vehicle in Eugene, Oregon, then they didn't have eyes on him because they would have known he was in Pennsylvania at the time. And so also, according to the state's documents, they can only do the genetic tree unless there is no lead. And so they had to have had no leads on him, which also brings up another question. They never changed the fact that they were looking for something newer than a 2013 Elantra. And one of the defense's arguments is that they never changed that vehicle until after they had Bryan Kohberger's name. And so they made that evidence fit Kohberger versus the other way around.
Yeah.
And so that's one big argument that they have.
Yeah. And then we have like If I remember correctly, there's surveillance footage of him of the white Elantra driving around
Yes.
the place. So
Yes.
I mean, really, we're talking about surveillance footage of the vehicle and cell phone records that just show that the cell phone was in the area.
Mm-hmm.
Right.
I mean, that's pretty weak if you think about it. You know.
Well,
Yes.
they still have 51 terabytes of information that they haven't said anything about yet.
Okay.
So I'm guessing if he did plan any of this attack, it will be somewhere in there.
Like in text messages or something like that.
Well, I think a lot of it though is like surveillance footage from different, because they have multiple, it says on there they have multiple angles or multiple footage of Bryan Kohberger's vehicle throughout 2 different cities. So I'm assuming that it's probably like 24 hours worth of surveillance on specific different cameras. But so the name Bryan Kohberger comes out. Now, you're right. One of the things that they have on him are the phone pings, and that's where my next question comes from. According to the probable cause affidavit, and I strongly suspect December 19th, they're like, oh, crap, we have this guy, Bryan Kohberger. Let's go build a case against him. First thing that they're going to want to do is find out about his whereabouts the night of the incident. Now, they go and get a warrant for his locations. Now, the warrant is suspicious to me. I'm gonna try to pull it up. All right, so the warrant that the information that they use to get the warrant for Bryan Kohberger's phone data pings there, it says based on information provided by the WSU website, Kohberger is currently a PhD student in criminology at the Washington State University. Pursuant to records provided a member of the interview panel for the Pullman Police Department, we learned that Kohberger's past education included undergraduate degrees in psychology and cloud-based forensics. These records also show Kohberger wrote an essay when he applied for the internship at the Pullman Police Department in the fall of 2022. Kohberger wrote in his essay that he had an interest in assisting rural law enforcement agencies with how to better collect and analyze technological data in public safety operations. Kohberger also posted a Reddit survey, which can be found on an open source internet search. That survey asked for participants to provide information to understand how emotions and psychological traits influence decision-making when committing a crime. As part of this investigation, law enforcement obtained search warrants to determine the cellular device that utilized cellular towers in close proximity to the King Road residence on November 13th between 3 and 5 a.m. After determining that Kohberger was associated both with the white Elantra and the phone, investigators reviewed the search warrants. A query was done, and the return shown that the phone did not connect to the sources in close proximity or to the tower in close proximity to the King Road residence. Based on training and experience, they believe that it says here, law enforcement officers specializing in utilization of the cell towers or cell records. As part of this investigation, individuals can either leave their cell phone at a different location before committing a crime or turn their cell phone off prior to going to a location to commit the crime. This is done by subjects in an effort to avoid alerting law enforcement that cellular device associated with them was in particular area when the crime was committed. They also goes to say that they know that, when they're planning the crime, that they'll keep the phone on. And so it says here that on December 23rd, he applied and was granted for a search warrant for the historical phone records between November 12th and November 14th. My question to you is, the mere fact that he was a criminology student and had information on how he would have been investigated, from a technological forensic aspect, enough to violate his civil rights to go look at his cell phone pings?
Probably not. Like, your argument is he's got specialized knowledge, and he potentially used that specialized knowledge to commit a crime and try to get away with it. And I don't think that inherently in and of itself would be like prejudicial to him per se, because they could have pinged like everybody in the area or everybody that was in order to argue prejudice, you'd have to argue that it affected him in a certain way that it wouldn't anybody else. So, I mean, who cares if he was a criminology student? You know, like his cell phone pings happened to ping at that place in that time during that time frame. So, I mean, I don't see that argument carrying water. I think the search warrant would probably stick. Like, it wouldn't be suppressed.
Really? Yeah, because I felt that if I was, I'm not an attorney or a defense attorney, but I always thought that, or I felt that just because he had knowledge of how to get away with it, so does everybody that attends the criminology department there in Pullman, Washington. And, are they doing a search warrant on everybody's phone pings that is connected to that program? You know what I'm saying? I think that you open up for that to being an issue. Now, do you think that the defense would have a leg to stand on to have his historical data phone pings suppressed?
Yeah, if the state can make, if the defense can make some kind of argument where that it was a violation of his Fourth Amendment right against search and seizures, like, back in the 60s, like, that was a big thing. Like, everything was excluded during that time, like the 60s and 70s. But the 80s onward, like, they kind of carved up the exclusionary rule to where, like, they made so many exceptions to it that it doesn't exist anymore. So I don't know. I think they'd be in an uphill battle trying to suppress the ping records, like, because we're talking about that tower, right? That specific phone tower.
Right. Well, they have some kind of cast thing that the FBI did where they're able to use historical data, and somehow it's more accurate than phone pings from the tower. Apparently, it measures the time it takes for a signal to go from the tower to the phone and back. And I think it's referencing his specific ping, so it would have been his location throughout that entire time and what towers he would have connected to. Now, initially, it was that specific tower, and what I think they did was they looked at the 3 to 5 range, the half-mile radius, didn't see Kohberger attached to it. His vehicle was a 2015. They thought it was a 2011 or 13, so they went on to the next person. They had like over 9,000 tips. So I think they were moving fairly quickly. I think that's fairly what happened. But all right, so if the defense wants to come out and try to suppress, the historical phone pings, at what point would we expect to see those motions? Should that be something that's happening now, already have had happened? Or is that something that we should see after this motion for, this whole grand jury thing?
It really can happen anytime before trial. Like, ideally, it should be happening now. Like, the sooner the better, because they're going to have a hearing in front of a judge to hash it out and to actually order it suppressed. So, like, the longer you wait, the more risk you have of the judge just saying, no, I'm not suppressing it. So it would behoove the prosecution to do it early, and I think now would be a good time to do it. Like, at least get the motion on file. Like, it might take like a month or two to actually get it heard, but like they really should be filing stuff now.
Yeah, 100%. What's up, Jaime? You have a question?
Well, I was wondering, we have information, right, about the phone pings, about the DNA and all that stuff. But how come we're not hearing the 911 call? What do you think that's the case?
It might be privileged. Like, there's a privilege in most jurisdictions called informer identity privilege. And if the 911 caller identified themselves who reported the crime, the state's going to want to keep that identity under wraps, like at least until trial. Like, there are some exceptions to that, but that would be my guess. Like, there's some kind of privilege that the state is trying to enforce against having one of their witnesses' identity disclosed.
That's interesting. here in this document that I have pulled up right here, this was the search warrant referencing the AT&T for Bryan Kohberger's historical phone pings. In here, it states Brett Payne, who was the investigating officer, having given me proof upon oath on this day showing probable cause establishing grounds for issuing a search warrant. Probable cause believe the property consists of certain evidence regarding the investigation of the crimes of the homicide at 1122 King Road in Moscow, Idaho, and that the AT&T account associated with the phone number, which is Bryan Kohberger's, between November 12th and November 14th. Information in the location is stored. Now, they asked, in the search warrant, it's privileged as to what exactly they're looking for and how to, issue that over. Now, there's a lot of documents in here. But this is the only one referencing the search warrant at that time. Everything else comes after the fact, like seal, like motion to seal and stuff like that. Now, I've seen other search warrants before, and usually they don't just say that the investigator gave them proof. They actually talk about the proof that was given. Like, for instance, in the Ronald Logan search warrant, where they searched his house in the Delphi murder case, they indicated that he had created an alibi prior to the bodies being found. And that was a sign that he had, beforehand knowledge of the crime, things of that nature. None of that is stated here. All it says is, Brett Payne gave him proof. What do you think about like a search warrant that's this simple?
No, you're right. It is supposed to be a lot more specific than that. Like, it's got to be based on clear and convincing articulable facts. And having given me proof, that sounds to me like that wouldn't cut it. I would attack that if I was a defense attorney, like try to, like a motion to quash the search warrant and suppress evidence gained as a result of that.
Yeah. See, this was one of the biggest issues that I have. And if they end up doing that, I mean, any evidence that they found or used because of that would be suppressed as well, right?
Yeah. That's the fruit of the poisonous tree doctrine.
Yeah.
Like, if the tree is bad, the fruit is bad.
Yeah. So, I mean, I see why Bryan Kohberger's defense team is fighting so hard. I think there is some stuff here that are going to be some hurdles for the state's, case. I do think that Kohberger's the guy. I think they got the guy. I think that there might be a possibility that the law enforcement may have jumped the gun a little bit. I think that maybe they should have found more evidence before arresting him.
Yeah.
Because it seems like after his arrest, they haven't found much.
Mm-hmm. Mm-hmm. It's not going to be a slam dunk, I'll tell you that. Like, and if I'm not mistaken, the trial is scheduled to last for 6 weeks. And judging by what I'm seeing here, like, it's anybody's guess. Because and remember, like, let's assume arguendo he is the guy. Like, the state still has to prove beyond a reasonable doubt that he did it. And, if they can't, then he's acquitted. Now, that being said, like the family members of the victims, they could still sue him civilly for like wrongful death. That's what they did with OJ. He was acquitted, but then he was found liable for the death of the woman. So even if Kohberger gets out of this, he's still not going to be out of the woods, I don't think.
Gotcha. Yeah. I think there's going to be some hurdles. I mean, just kind of going over everything. You have the Brady Giglio. You have the possibility of only one source of DNA on the sheath. You have, in my opinion, this very weak, deal here when it comes to his search warrant for his phone pings. Now, I think that they have given me proof is, hey, we got the genealogical stuff that we can't use, but it's pointing at this guy, and the judge is like, all right, cool. That's good enough for me. Let me sign off on this. I think that's probably what happened.
Sounds like it.
And do you guys have any other last questions? We're getting kind of close to the end here.
Yeah. Well, go ahead, Jaime. Go ahead.
I agree with you, Danny. They should have, looked for more evidence in the beginning than the end, right? Because if it doesn't go in their favor, and he gets a non-guilty verdict, he can't be charged again for the same crime, right?
Nope.
Yeah, the double jeopardy. Yeah.
Mm-hmm. So that's gonna be a big loss.
Mr. Lutz, I had a question for you.
Okay.
If you were defending him, and he already pleaded the fifth, would you allow? Would you? I mean, it's up to him, but do you think it's a good idea for him to plead the fifth again during the case, during the court hearing?
It wouldn't hurt. I mean, he's already pleaded the fifth, so I mean, like, as long as the pleading is on record, I mean, it wouldn't hurt for him to plead again. And frankly, I think this was another topic on that last show you had. Like, is he going to testify? Yeah. If I were his lawyer, I'd advise him not to testify. Like, because I really haven't liked anything he's like said thus far. And I don't think any kind of testimony would help him, like, from him. So I would advise him to not testify, just keep his mouth shut. So pleading the fifth is probably the best thing for him individually. And if the state wants to re-invoke that, like, because see, here's another thing that y'all might not know about. Like, when you're like when you're arrested and you're questioned, and you think, I plead the fifth, like I plead my right to silence and my right to counsel. They can the police can leave you alone and then come back 30 minutes later and try the same thing. And you actually have to plead your rights again, like while you're being questioned. Because if you start spilling the beans, if you start talking, then they can use that against you. So a lot of people don't know that they can stop the investigation and restart it. They can start the interrogation. They can stop and then restart. So it's probably a good idea to plead the fifth again, like on the record, just to have it, just for safety's sake.
Well, that makes sense, because I know that there was some statements that were out there that apparently at his arrest at the Pennsylvania, investigators were talking to him a little bit, and then he asked for a lawyer, and then we found out that the defense has been sending in motions that they want a copy of, I guess, another interview that Kohberger did with investigators from Moscow over the phone. And there was a big question, like, well, if, he asked for his lawyer at one point, is that true? That I guess, it seems like it's possible that he could have spoken to Moscow over the phone after all. And that'd be a completely separate situation from when he invoked his rights for counsel the first time. Mm-hmm. Interesting.
Yeah, you got to be really careful with the police. Like they are not your friends. They are there to put you in jail.
That's true. That's true. Do you have any, Zach? Do you have any questions for us or comments or anything?
Not really. I mean, like, it's been a wonderful group, wonderful chat, and very educational. I didn't know much about this case, and now I learned quite a bit about it. I think I'll be following it from now on to see what happens. I guess it's the next Casey Anthony case, right?
Right. Yeah. Yeah, it's definitely one of the bigger ones that is going on right now. Yeah, we're going to be covering it. There's a court hearing on the August 18th referencing the grounds for dismissal on the grand jury. We'll see how that goes. We'll be going live then. I'll be going live tomorrow as well. So make sure you hit that like and subscribe button. I'm going to be going over some of the maps and the routes that Bryan Kohberger may have taken after the fact and the following day as well. You don't want to miss it. So make sure you hit those buttons. Zach, thank you so much for joining us. We appreciate you and giving us, your professional insight on a lot of the questions that we had. Thank you so much. Again, you guys, if you guys are interested in an attorney, if you have some criminal issues or family law issues, look up Zach. His information is in the description, and he'll be a man to take care of you guys.
Yeah. Thank you very much for having me. Really appreciate it.
Thank you for being on.
Yeah, thank you.
That being said, we'll see you guys tomorrow.